Have you ever wondered why online platforms, from social media giants to small forums, seem immune from lawsuits over content posted by their users? It is a complex issue at the heart of how we interact online, sparking endless debate about responsibility and free speech. While Section 230 of the Communications Decency Act provides broad immunity for interactive computer service providers, shielding them from liability for third-party content, this protection is not absolute. Specific statutory exceptions and judicial interpretations have carved out important limitations, meaning platforms are not entirely off the hook for everything. These exceptions exist because Congress, and later the courts, recognize that certain harms transcend the need for blanket immunity, or that platforms themselves might engage in activities that fall outside the scope of merely hosting content. The core principle of Section 230 is to prevent platforms from being treated as a publisher or speaker of user-generated content, thereby fostering an open internet. However, this foundational idea does not extend to all forms of harmful or illegal activity. One significant category of exceptions involves federal criminal law. Section 230 explicitly states that its protections do not apply to the enforcement of federal criminal statutes. This means if a user posts content that violates a federal crime, such as child exploitation material, the platform can still face criminal liability, even if they are not considered the original speaker. Additionally, intellectual property laws, such as copyright and trademark infringement, are also outside the scope of Section 230's immunity, allowing rights holders to pursue claims against platforms for user-uploaded infringing material. Another crucial exception is found in the Electronic Communications Privacy Act, often referred to as ECPA. Section 230 does not immunize platforms from liability under this act if they unlawfully intercept or disclose electronic communications. Perhaps one of the most impactful recent changes came with the passage of the Stop Online Sex Trafficking Act and Fight Online Sex Trafficking Act, known as SESTA and FOSTA. These laws specifically carve out an exception for state and federal civil actions related to sex trafficking, making platforms potentially liable for knowingly facilitating or promoting such illicit activities. To understand how these exceptions might apply, consider the nature of the content and the platform's involvement. If the content directly violates a federal criminal law, like child pornography, or infringes on copyright, Section 230 generally offers no defense. Furthermore, if a platform is directly involved in creating or materially contributing to the illegality of the content, moving beyond passive hosting, it may also lose its immunity. This distinction between being a passive host and an active participant is often central to legal challenges. The landscape of Section 230 is continuously evolving, with ongoing legislative debates about further modifications. Understanding these established exceptions and the fundamental reasons behind them is crucial for anyone navigating the legal responsibilities of online platforms. It provides insight into the delicate balance between fostering an open digital environment and holding entities accountable for truly harmful online actions, ensuring a more responsible and transparent internet for everyone.